उद्धव गुट बनाम शिंदे गुट अयोग्यता के मामले में सुप्रीम कोर्ट की संविधान पीठ ने 7 सदस्यीय संविधान पीठ के पास इस मामले को भेजने से फिलहाल इनकार कर दिया है। कोर्ट ने कहा है कि इस मामले की मेरिट को देखते हुए और सुनवाई की जरूरत है। यह मामला बेहद दिलचस्प है। सुप्रीम कोर्ट को 2016 में दिए गए नवाब रेबिया बनाम डिप्टी स्पीकर केस के फैसले की वैधानिकता तय करनी है, जिसमें कहा गया था कि अगर स्पीकर या डिप्टी स्पीकर को हटाने का नोटिस विधायकों ने दे दिया है तो स्पीकर या डिप्टी स्पीकर विधायकों की दल बदल कानून के तहत अयोग्यता तय नहीं कर सकते। इस याचिका पर कॉन्स्टिट्यूशनल बेंच में अगली सुनवाई 21 फरवरी को होनी है।
During the course of the hearing, a preliminary submission has been made before the court to the effect that the decision in Navam Rabia and Bamang Felix versus Deputy Speaker, Arunachal Pradesh Legislative Assembly requires reconsideration by a bench of 7 judges. Mr. Kapil Sibal, Dr. Abhishek Manu Singhvi, and Mr. Devdatta Kamath, learned senior counsel, seek a reference to a larger bench. The submission has been opposed by Mr. Harish Salve, Mr. Neeraj Kishan Paul, Mr. Mahesh Jetmalani, Mr. Maninder Singh, and Mr. Siddharth Bhatnagar, learned counsel appearing for the other side. Mr. Tushar Mehta, learned Solicitor General, appeared on behalf of the Governor of the state of Maharashtra. Arguments have been concluded on the issue as to whether a reference should be made on the correctness of the decision in Nabam Rebia to a bench of 7 judges. In Nabam Rebia, 3 judgments were delivered for the Constitution bench by Justice J.S. Kehar, Justice Deepak Mishra as the learned Chief Justices then were, and by Justice Madan B. Lokur. The opinions of Justice J.S. Kehar and Justice Deepak Mishra hold that the Speaker should desist from considering a petition for disqualification under the 10th schedule to the Constitution when a notice indicating an intent to remove him has been moved. This principle is formulated in the following observation in the decision of Justice J.S. Kehar, para 194. We hereby hold that it would be constitutionally impermissible for a speaker to adjudicate upon the disqualifications petitions under the 10th schedule while a notice of resolution for his own removal from the office of speaker is pending. A similar view has been expressed by Justice Deepak Mishra in the following extract from para 238. When there is an expression of intention to move the resolution to remove him, it is requisite that he should stand the test and then proceed. That is the intendment of Article 179C, and the said interpretation serves a litmus test of sustained democracy founded on rule of law. And the founding fathers had so intended, and the constitutional value, trust, and morality unequivocally so suggest. It would be an anathema to the concept of constitutional adjudication if the Speaker is allowed to initiate proceeding under the 10th schedule of the Constitution after intention to remove him from his office is moved. However, Justice Madan B. Lokur, in the course of his judgment, held that, para 401, in the view that I have taken, I am of the opinion that the view expressed by my learned brothers relating to the power or propriety of the Speaker taking a decision on the 10th schedule of the Constitution with regard to the 14 members of the Legislative Assembly does not at all arise in these appeals. The issue of whether a reference to a bench of 7 judges should be made cannot be considered in the abstract, isolated or divorced from the facts of the case. Whether the above principle which has been formulated in Nabam Rebia has an impact upon the factual position in the present case needs deliberation. In the above backdrop, the issue whether a reference of the decision in Nabam Rebia to a larger bench is warranted would be determined together with the merits of the case. Consequently, the batch of cases is set down for hearing on merits on Tuesday, 21 February 2023 at 10:30 a.m.